Hello, my name is Becky Haynes, Director of Consulting at Landrum HR. On November 15, 2016, Landrum HR hosted a live webinar to give business owners an update on employment law, particularly the changes surrounding the Fair Labor Standards Act, workers' compensation, and the Affordable Care Act. In the following segment of our webinar, Colleen Ortiz, a Pensacola workers' compensation attorney who's been practicing for more than 20 years, discusses a little background about how workers' compensation works, as well as the two recent challenges to the Florida workers' compensation statutes that brought about the changes and premium increase. Since the original airing of our webinar, the laws on workers' compensation continue to evolve. We invite you to visit our blog at landrumhr.com for the most recent information on these state and federal issues.
Colleen, I have read that the National Council of Compensation Insurers, which I think is the NCCI, approved a substantial rate increase which increases the insurance premium that employers have to pay in the state of Florida. Is that correct?
That is correct. On December 1st of 2016, the work comp premium rate is going up by 14.5%.
14.5. That's a large number.
That is a very large number. And we're here to tell you a little bit about why that happened. The rate increase was primarily caused by two different workers' compensation challenges to the Florida workers' compensation statute. And those cases were Westfall versus the city of St. Petersburg and Castellanos versus his employer, which was called the Next Door Company. And to understand these constitutional challenges, it helps to understand a little bit of the background about how workers' compensation laws work. If you have a personal injury lawsuit, you are required to prove that the injured party is required to prove that the other party was somehow negligent.
Right.
And if they do that, then they can collect damages for being out of work, for their medical bills, for any permanent injuries that they've sustained, as well as pain and suffering. However, if they can't prove that the other party was negligent, then they don't get anything. In workers' compensation, it's a little bit different. It's been called the grand bargain. Just by virtue of being in the workplace, workers are at a higher risk of injury.
Because they spend so many hours there every week, I presume.
Right,
Is
and
that the
sometimes
reason?
the labor is pretty intensive, lifting and that's dangerous machinery around, that sort of thing. And to protect workers from what could be the devastating effects of a work injury, very high medical bills, being out of work, not having their income, not being able to provide for their families, workers' compensation laws were enacted. So the grand bargain is that in exchange for employers having to pay injured workers benefits if they are hurt on the job, injured workers, regardless of whether there was any negligence or not, the employers are responsible. The injured workers receive limited damages. And under the workers' compensation laws, those damages are limited in that the amount of money that they get for loss of income is calculated by statute. Medical bills are paid by the employer at a fee-scheduled amount. Permanent injuries, such as a loss of a finger, is also paid according to a guideline, and there is no pain and suffering. Over the years, there has been a significant increase in the cost of workers' compensation claims to employers and carriers, and therefore there have been new laws enacted to kind of help curtail these rising costs. And every time that happens, injured workers' attorneys challenge these laws, claiming that they have reduced the amount of benefits that injured workers are entitled to such a degree that these injured workers no longer get the benefit of the grand bargain. The Westfall case and the Castellanos case are just two of the cases that have come to the Supreme Court, and those were two cases that were successful. In Westfall, the Florida Supreme Court ruled that a limitation on the amount of benefits that an injured worker can get while being out of work, that limitation was unconstitutional and invalid. And in Castellanos, they ruled that the amount that employer carriers pay injured worker attorneys, that limitation was also invalid.
Well, Colleen, tell us more about the Westfall case and what it's done to workers' comp cost.
In 1994, the legislature tried to curtail rising work comp costs by limiting the number of weeks that an injured worker who was off of work due to a work injury temporarily could receive. They limited it to 104 weeks. And Mr. Westfall challenged that limitation. And I do want to say that everything that we're talking about here is very general because there's
Sure.
an exception to every rule. But in any event, Mr. Westfall was a firefighter, and when he was injured on the job fighting a fire, he hurt his back and his knee. When the 104-week limit was reached, he was still recovering from a second back surgery.
And that's 2 years, right?
That is 2 years, yeah. And so even though he couldn't return to work, under the law, he was no longer entitled to benefits for lost wages. He still got his medical bills paid, but there was no income coming in. And he didn't think that was fair. So he took his case to court, and it wound its way up to the Florida Supreme Court. And the Florida Supreme Court agreed with Mr. Westfall. They said that the 104-week limitation was not sufficient to meet the grand bargain. They addressed the constitutional issue, and they said that the limitation was an unconstitutional denial of his right of access to courts because it did not function as a reasonable alternative to personal injury litigation. They said that the prior limitation of 260 weeks, which is 5 years, was valid. They said that they had previously addressed that, and it passed constitutional muster. So what we have now is that instead of a limitation of benefits for being out of work of 104 weeks, employers are exposed to a limitation of 260 weeks. So 2 years, no longer 2 years, but 5 years for being temporarily unable to return to their jobs. This change in the law is definitely going to have an adverse effect on employers, but it doesn't happen all that often. So it's not the largest piece of the puzzle as far as the responsibility for the rate increase.
I would imagine there are not that many employees who are out and in need of income and medical treatment for up to 5 years. That's probably a small percentage.
That's true, and usually if they're going to be out that long, they may cross over into the permanently and totally disabled category, which is another story altogether.
A completely different webinar.
That's right.
Okay, we'll save that one for another webinar.
Okay.
So that's Westfall. But you said there was a Castellanos case as well, and that one has to do with hourly fees for employers who are represented, or for attorneys who represent their individual clients.
For injured workers.
For injured workers.
Right.
Got it.
Just like in the Fair Labor Standards Act, there are occasions in which the employer carriers have to pay the attorney's fees, not only of their own attorneys, but those of the injured workers' attorneys. And yes, the Castellanos case, that's what that was all about. And that is the primary reason for the high rate increase. In fact, over 10% of the 14.5% is directly attributed to the Castellanos decision. There are a number of ways in which employer carriers are responsible for injured worker attorney's fees, but the two main ways are if a lawsuit is brought and it goes to court and the injured worker wins, then the employer carrier must pay the injured worker's attorney. The other way is if they just bring a claim, if the injured worker's attorney brings a claim and the employer carrier says, oh yeah, we owe this benefit, but they don't pay it in a timely manner, then they also are awarded, the injured worker attorneys are also awarded fees.
Okay.
This has been a problem for years, and the legislature has tried over the years to come up with new statutes to bulletproof a cap on injured worker attorney fees, and every single time that they do that, it's challenged, and so far, every single time it's been challenged, it's been overruled. And the latest one is the Castellanos decision. Before the Castellanos decision came down, how attorneys' fees were calculated, and this was after the law change in, I think, 2003. In any event, but before Castellanos, it was calculated by a percentage of the benefit that they recovered for the injured worker. So if they recovered $1,000, then they would get a percentage of that as their fee paid for by the employer carrier. And in Mr. Castellanos' case, that worked out to be a fee of $164.54 for 107 hours of attorney time.
Okay, so wait, let me clarify
pretty
that. Okay, so let me clarify that. The attorney worked however many hours,
107.
107 hours, but because the benefit recovered was low,
Correct.
the employee won, the
He did.
benefit was paid. It should have been paid initially, it was, and it was eventually paid. But because the recovery was low, the plaintiff's or the claimant's lawyer only got $1.50 an hour.
Yeah, maybe not quite.
Maybe not quite $1.50.
That's right. So it was less than minimum wage.
I can see why that would be a problem.
Well, there are arguments on both sides,
Yes.
but yes, that would definitely be a problem. And Mr. Castellanos' attorney argued as such. He said that this fee limitation was an unconstitutional limitation on Mr. Castellanos' right to due process. He said that there was no way Mr. Castellanos could have ever won this case without an attorney, and he said no attorney in his right mind is going to routinely take on these cases to help injured workers get benefits that they're entitled to. And you know, a $1,000 MRI might not be much for an insurance company, but it's a lot for an injured worker. And so, so he said, you know, attorneys aren't going to take these cases, and so this is unconstitutional, and that's why that was his argument before the Florida Supreme Court. And the Florida Supreme Court agreed. So we went back to the old method of calculating attorney fee damages or amounts, and in Mr. Castellanos' attorney's situation, instead of $164, he received a fee of $37,500.
Oh gosh, so we went from $100 to $37,000.
Yes.
Wow, that's
yes.
quite a swing on the pendulum. That's a big
kidding.
difference.
Yeah.
Yes, it is.
So one thing that we all learned in law school was how long it takes a case to wind through the court system from the time it's initiated till the time it maybe gets to the Supreme Court, and it can be a number of years. And in past years, Todd, you and I have talked about the National Labor Relations Board,
Right.
And how as they were taking actions, there were cases that were pending and decisions being made, and the law may have changed later, but that didn't affect those opinions retroactively.
Right.
So I can only imagine that with the workers' compensation change, it probably took several years, and there were probably many pending cases where the law might have been applied differently?
That's correct. It took about 4 years from the time that the lawsuit was filed in Castellanos until the Florida Supreme Court entered its ruling. And during that time, probably hundreds of cases were filed on attorney's fees, and they were pending, awaiting resolution of the Castellanos decision. And when that case came down, all of those cases had to be paid at the hourly rate rather than the percentage rate. Just for an example, shortly after Castellanos came down, I was, keeping updated with new cases, and I read a case in which the fee under the percentage system was $1,600, but under the hourly rate system, the judge awarded that attorney $42,000. So this is just
Oh my gosh, that
Gosh.
is amazing. Yes.
right. This is you can see why this decision is having a tremendous effect on employers.
Absolutely.
So I guess it's created a larger volume of cases of this nature?
Oh, yes, yes. The lure of these high attorney fees has definitely resulted in more litigation. The Castellanos decision came down on April 28th of 2016, and there was a comparison of the number of lawsuits filed in May the year before it came down and in May the year after it came down, and there was a 24% increase in cases filed.
Great. Well, what can employers do to keep their costs down?
Well, one way that employers can keep their premium costs lower is to keep their experience cost low.
Their mod.
Right. And they can do that by maintaining a safe work environment. Another thing that employers can do is get injured workers back on the job as quickly as they can. Even if an injured worker can't return to his or her full duty job, bring them back light duty. It is critical to get an injured worker back into the day-to-day routine of getting up in the morning and going to work and not focusing on their injury for not only the lost time issue, but also for their recovery. And studies have shown that the longer that an employee is out of work, the less he or she is ever likely to return to any kind of employment. If they're out for fewer than 6 weeks, then they're the most likely to return to working in their old position. If they're out for 6 months, that drops to 50%. At 1 year, it's 25%, and at 2 or more years, they're unlikely to ever return to work. And that's when we see those very costly permanent total disability cases.
Right, right. Tell us about Landrum. Do they have policies and procedures that help with these issues?
Yes, they do. One of the significant cost drivers I've seen in my practice is poor claims management. In other carriers that I've worked for, they have adjusters that are just so overloaded with work that things slip by, and benefits that should never have been paid and claims that never should have been picked up are paid or picked up. And the best way to prevent this kind of thing from happening is diligent claims oversight. Landrum's risk management staff is very diligent, and they keep a very close eye on each and every one of their claims to make sure that if a benefit should be paid, then it's paid. But if it shouldn't be paid, then it is not paid. They've also developed strong relationships with area physicians who understand Landrum's goal of getting injured workers back to work as quickly and as safely as possible. And finally, if benefits are owed, then they are timely paid, and that helps prevent incurring these astronomical claimant attorney fees that we've seen, the injured worker attorney fees.
So it sounds like getting people back to work, it's a win for the employee to return to work, and it's a win for the employer to control their costs.
Absolutely. And as a matter of fact, when they've had studies that have shown when you even have two similar injuries, if the person comes back, for example, carpal tunnel surgery, if an injured worker comes back within a few weeks, their medical costs are lower than a person who's out for 2 months or 3 months for the same surgery.
Interesting.
Yeah, it really is.
So, Colleen, legislatively, what is the state of Florida thinking of when they convene in the spring?
Well, I'm not aware of any specific bills that are pending at this point. However, I do know that there are several Florida agencies that have developed task forces to explore legislative solutions. 2 of those are the Florida Chamber of Commerce and the Associated Industries of Florida. And I spoke with a woman with the Florida Chamber, and she said that several bills have been drafted and have been sent out for review. Additionally, she said that one possibility to curtail the amount of attorney's fees that are owed under the Castellanos decision is to put a cap on the hourly rate that injured worker attorneys receive. So for the Castellanos, for his attorney, he would have been paid for 107 hours worth of work, but it would have been at a much lower but still reasonable hourly rate.
Okay, that makes sense. That makes sense. Thank you, Colleen. I think that's going to be really helpful for all of the employers out there.
Good information.